Hey guys, hope everybody's doing well. Today we're going to be looking at the First Amendment's free exercise clause. Last week we looked at the Establishment Clause and what the Constitution said about that. So this week we're moving on to the next, 5 words. So last week, Congress shall make no law respecting the establishment of religion. This week, Congress shall make no law prohibiting the free exercise thereof. And so from the question we're going to ask today is basically what does that mean versus, maybe what did it mean? So the first case we're going to look at in all of this kind of gives us our starting point. And as much as we want to say that, we have freedom of religion, what exactly does that mean? And the short version is you're free to believe whatever, you really want to, whether that's, some very old Orthodox religion or you want to make up something new. Like some, people have done, put a colander on your head, call it a religious garment, and, make sure you get your driver's license taken with that. But what you can't do is just whatever you want in the name of your religion. And, where do we see that clearly laid out? Well, of course, we have a case on that. So this case is a pretty old one. So you see it on the screen there, Reynolds versus the United States. This is a case that comes out of Utah, back when it's still a territory, involving the Mormon Church. Reynolds was actually the secretary to Brigham Young. And this is one of those cases that is designed to challenge federal law. Often we'll find those. We'll talk about that. Particularly we talk about the modern African-American civil rights movement with like Brown versus Board, where you have groups like the NAACP that are looking for people that are willing to challenge laws. This is one of those. So Reynolds is a Mormon, and way back when, the Mormons still practiced polygamy. And so he had married an additional wife and gets arrested and fined and all that sort of stuff and challenges his conviction. And the basis of his challenge was the free exercise clause. And he says that he is religiously obligated in order to do that, to be a polygamist if he's able to, and he's able to because he has the money and all that sort of stuff. And so he challenges law, and there's some other parts to it, but this is what we're worried about. Works its way up to the Supreme Court. So the question the Supreme Court is trying to answer is the one you see there. Is religious duty an allowable defense against following civil law? So, being a Mormon, does that mean, you can be you can practice polygamy despite laws against it? And well, the answer is going to be no. And so there's several things that go into this, but part of the majority's ruling you see on the board there, Congress was deprived over all legislative power over mere opinion. So this gets back to what we said. You can believe whatever you want, really. Come on, get on social media. People believe all sorts of stupid stuff. But was left free, Congress that is, was left free to reach actions which were in violation of social duties or subversive of good order. So basically what we're saying, polygamy is not good for society, according to this ruling. And they're going to go even further in this and basically sort of what we sometimes call the parade of horribles. If we allow this, all of these other horrible things will happen as well. And basically, if we allow polygamy, this leads to further things. And, this could be, somebody resurrecting human sacrifice as a valid religious practice. And so this is a good example. You can't do just whatever you want in the name of your religion if it goes against sort of public order and public morality. And so that's a good example of the limits there. Now, on the other side is, can the government, state or federal, limit your actions just because they don't like your religion? We kind of saw some of that with Mormonism, but as you see up here on the screen, an incorporation case. Jumping ahead to the 1940s, Cantwell versus Connecticut. This is a case that's going to involve the Jehovah's Witnesses. They actually bring a number of cases. They had a very active legal side led by a lawyer by the name of Hayden Covington. He's responsible for bringing a number of cases in front of the Supreme Court. He loses a bunch, but he also wins a handful of ones that give us some actually really important decisions over time, including this one. So the background of this case involved a father and his two sons, both all of them rather, were members of the Jehovah's Witnesses, and they were out proselytizing as that group is wont to do, and they were walking through the streets in this town in Connecticut, passing out literature. But the other thing they were doing was they had this portable record player, and they would play these records that, have these little speeches from their leader. And this particular record they were playing was really strongly anti-Catholic. It was actually from a publication just entitled Enemies, that particularly described Catholics as being like the enemy of the American people and of God. And it turns out they're proselytizing in a mostly Catholic town, so you can imagine how well all of this is going to go over. So they play this clip, or this record, for a couple of guys who, of course, are unhappy with it, basically sort of threaten them to go away. The cops show up, and these guys say that they're on the verge of assaulting these witnesses because they're so angry about what they've heard. And the Jehovah's Witnesses, who have never been particularly popular because of some of their beliefs and stuff, get arrested. And they're charged with two things. One is inciting violence or disturbing the peace. And the other was soliciting donations without a permit. And Connecticut had a law that required anybody who was soliciting, basically asking for money, to get approved. Now, one of the issues here, was that local officials would decide if they were going to give you the permit or not. And they could distinguish between, religious solicitation and an actual bona fide charity. And this was really an anti, Jehovah's Witness law, at least, in part, and that's how it was applied. And so what's going to happen is the Supreme Court says that states cannot do this. And so they're going to apply the Free Exercise Clause. Here, they're going to strike down this law and say, just because you don't like what these people are doing or how they're acting or anything like that, or their beliefs, and in this case, their actions they don't harm society. They don't upset good order. It's just that you don't like them. And you know what? We get to deal with that. So this is a pretty important case, and it leads us and it starts building us towards some others. All right, so a case you utterly have to know in all of this is the Wisconsin versus Yoder decision. Of all the ones that we're going to talk about here, if you're studying for your AP exam, since you're studying for AP exam, this is the one that you're going to need to be familiar with. So this is a more recent case, 1972, comes out of Pennsylvania. And you see the question in front of the court there. Can Amish children be required to go to school beyond 8th grade despite their parents' religious beliefs? Okay, so if you're Amish, as you turn 15, or which is about when you're going to graduate, 8th grade, just prior to going to high school, Amish youth would be taken out of school and they would basically begin their vocational training. And this is the time when they're really getting ready to take up a work or a particular craft and become a member of the Amish community. But Pennsylvania had a law that said you had to stay in school till you were 16. So we're really just talking about a year here. And a couple of parents are going to sue when they get in trouble for, taking their kids out of school and not sending them all the way through. And again, law is going to play out through the courts, is going to reach the Supreme Court. And the Supreme Court's going to side with Yoder in this one. And they basically say that the state cannot compel these parents to violate their religious exercise, their religious beliefs, because of the state's interest. And what one of the things the court does here is applies what we call strict scrutiny. And basically, you've got to balance two things out, right? On one side, you have a valid interest by the state to educate youth. And Wisconsin, and I actually said this case was from Pennsylvania. Clearly it's not. Wisconsin has an interest in, these people being, or these children being educated. And they actually make the argument that they don't want them to become like burdens on the state, like they're going to need social support or something like that. And, that's a valid interest. And on the other side, you have a parent's valid interest to raise their children, in their religious community. And the court's going to side with Yoder. And they basically said that the state's, compelling interest does not rise to the standard of allowing it to override the free exercise of these parents. And as we're going to see, as the court sort of fine tunes this a little bit, basically what they're going to say is, and we're going to see, is that the government can't just apply these really broad laws over religious practice. They have to be very narrowly tailored if they're going to do something like this. Okay, so this education law's out. Yoder wins, and it's one of the reasons why Amish youth still don't go to high school. So that's a really important case. It's one you're going to have to know. It's considered the big free exercise case. And once again, we're talking about school-age religious stuff. Okay, so the next couple cases that we're going to look at in all of this are much more modern. And so they're getting into some of the kind of current issues that we're trying to deal with. The case that's coming up, the Employment Division case, basically Oregon versus Smith is the short name, used to be a really common question on the AP exam, particularly in the multiple choice section. The way they're rewriting it, and saying you have required cases, who knows where it's going to go, but it's still a very interesting case. So, and students are usually interested in this one because it involves peyote, which is a hallucinogenic drug. And so now I have your attention again. And so the background of this case is that you had two guys who were both members of the Native American Church and had been on a religious ceremony, had been in a religious ceremony where they had used peyote, which, like I said before, is a hallucinogenic. They also happen to work at a drug rehab facility. And so they go back to work and they take drug tests, and eventually it comes out, of course, that they've been using peyote, and they get fired. And as many people do when they've been fired, they're going to apply for unemployment benefits, and they're denied their unemployment because they were fired with cause. If you're fired because you messed up your job, you don't get unemployment, it turns out, in most places. If it's your fault, you lost your job, the state's not going to help you out. Now, if they just fired you for no reason, it'd be different. But in this case, because they worked at this drug rehab facility, and in Oregon, peyote, by the way, is illegal, they essentially said, yeah, you don't get the benefits. So they're going to take the Employment Division to court. They actually are going to win at the Supreme Court, the state Supreme Court level, but it goes to the federal Supreme Court. And this is going to end up getting overturned. And so the issue with this case, and why we talk about this case, is the standard that's used here. If you remember from just a second ago, we talked about the Wisconsin case. We said there they used strict scrutiny. Here they were using a lower standard. And basically they were just sort of, if you see here, with a more lax standard, basically all they asked was, instead of, does this place an undue burden on your religious practice, just as a blanket question. In the Employment Division case, what the court does is it takes this lower standard and it says, as you see there, the government may burden religious practice if the law is neutral and generally applicable. So basically what they say here is, like, while this may interfere with these two guys and their religious practice, the law itself isn't directed at religious practice. It's a drug law, and it's targeting all of the citizens of Oregon. And so therefore it's a fair law. And as we go way back to our first case, right, the state has a compelling interest in regulating, moral behavior, and drugs fall within that. And so these two guys lose. And this was actually a pretty well-known case at the time. And so much so, and particularly it picked up steam because you have, the Native American aspect on this, and obviously in American history, groups that have been just, targeted and mistreated and everything else by both the state and the federal government. And so Congress responds to this one with an act, the Religious Freedom Restoration Act, in 1993, that we're going to come back to because it's a pretty important one. But just hang on to that one a second. So in Employment Division, they basically say, yes, you're allowed to burden religion if the rule is neutral and it's generally applicable, right? It applies to everybody, and you're not particularly targeting religion. A good example of that same idea being applied, and so a way of freedom religion, is the following case. The Church of Lukumi Babalu A. And so this was a court case involving a church that practiced Santeria, which is a African Caribbean religion that's probably not familiar to everybody. But one of the aspects of it is animal sacrifice. And so it was announced that this church was going to build a center in this community, and that would be, of course, part of what's going on. And so the city responded by passing some zoning laws, making animal sacrifice illegal. Couldn't take place within that area. And the issue here is that clearly, what's the point of this law? If it's passed right after this is announced, when it's targeting this particular religious practice, just because they don't want it in that area, if we use this standard that we saw in the employment division case, the Oregon versus Smith case, is that law neutral and generally applicable? Well, no, you're targeting this particular group. And so in this case, the church wins. And so, free exercise says you can practice Santeria, you can have animal sacrifice, but you can't smoke peyote or ingest peyote. And a lot of this has to do with how are we applying the laws, which is, can get a little bit confusing on some of these things. Okay, hopefully all of that made sense. If not, let me know. We do want to go back to that act real quick, the Religious Freedom and Restoration Act, 1993. And why that act matters is because it affects how the court is playing things out right now. So this act required a couple of things, but the one that matters for us and for AP government is that this required that the court use strict scrutiny when examining laws that affect religious freedom. And so it requires this heavier standard. And what do we mean when we say strict scrutiny? Is that there has to be a number of things, a number of components that are met. There has to be a strong and compelling state interest, not just sort of a general, like this would be nice kind of, want. Whatever law is passed has to be narrow. You can't have these big, broad, laws that cover a whole bunch of stuff. And is this law using the least restrictive means to achieve whatever purpose it wants? So compelling state interest, narrowly tailored, and least restrictive. And what this really is going to do is say, if you're going to do a law, so let's go back to the Oregon case. What that would say is, does the state have a compelling interest in regulating drug use? Well, yes, we would say. Is the law narrowly tailored? Okay, well, if we look at the use of peyote in this situation, it's in a religious ceremony that is taking place in private property, that is heavily monitored, and all of those sorts of things. Is that really a danger to society? And so if we're saying the law must be narrowly tailored and be the least restrictive, if we apply the strict scrutiny standard to the Oregon case, those two guys win instead of losing. And that was kind of the purpose of the act, was to make sure that things like that didn't happen. And you see this was a quote from the text of the law: "The government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability," so that the law is, fair and all that sort of stuff. So this is one of those laws that has probably some, good intentions, but has kind of been used for a number of things. The other thing about the way this law is written is that the Congress tried to apply this to both. It's both the federal government, but also to the states. Think back to the Oregon case, right? It's about Oregon. That's a state. And so pretty quickly, it's going to be challenged. So the city of Bourne versus Flores case involved a church, I think, that was trying to expand. And went up against zoning laws, and the city wouldn't back down. So the church used this this law, or tried to use this act to get the zoning rules overturned. And in this case, they lose. And basically, what they say, the court says, is that the act has gone too far in trying to dictate things to the states. And so it gets invalidated, or at least a portion of the law gets invalidated. The federal government still operates under this. What do we need to know about all of this? Why are we getting in all of this? So when the court strikes down essentially the state portion of the RFRA, is that a number of states start passing those acts. And that becomes a big issue today. And so often these religious freedom acts, where it gets controversial, is in fairly recent history, has to do with LGBT rights. And so you had a number of states, quite famously back in, I think it was 2014, 2015, Indiana passing a number of laws around, we often see this around bathroom bills, allowing transgender people to use the bathroom of the gender they identify with. Earlier, back before the court decision allowing for gay marriage, laws that would prohibit those sorts of things. And often the RFRAs at a state level were designed to protect, or at least they were portrayed as trying to protect, religious individuals who didn't want to, serve gay people, or provide services or things along those lines. And it became it is very contentious. And so often these RFRAs, things at a state level, are maybe less sometimes about protecting, or at least definitely perceived as being less about protecting, from government overreach on something like, peyote use in a religious ceremony, to maybe being something else. So that's your current event sort of application. Okay. A couple of current examples of cases, both of these that just went through the Supreme Court. And so we're still basically sorting out what is free exercise and how far does the Establishment Clause go. An establishment case, since that's what we're just talking about, is the American Legion versus the American Humanist Association. It involves that giant cross that you see there on the screen. That was built in the aftermath of World War I as a commemorative cross to soldiers that had served, but more importantly, soldiers that had died from Baltimore and the surrounding area. Today, that cross is in the middle of a pretty busy sort of interchange. There's like highways on either side of it. It's in this park that's sort of in the middle of these series of roads, and it's maintained by the state. So you have government money going to maintain this giant cross statue. And so the American Humanist Association and some other groups sued, and claiming that that was violating the Establishment Clause, that was, promoting a single religion. What the court's going to say on this one is that this is a historic element, that this is something that has been going on for a long time. Rather, this cross has been there for a long time. It's understood as a war monument, and that crosses and graveyards, particularly in World War I, were very common. And so they actually upheld, in that case, the state still maintaining this cross. The Masterpiece Cake Shop case is one that's probably a familiar theme. This comes out of Colorado. Masterpiece Cake Shop, the owner there refused to make a custom cake for a customer's wedding, a gay customer's wedding. Gets sued in the Colorado Civil Rights Commission, and loses the case, and is going to appeal to the Supreme Court. And the argument comes there is creating a cake a form of religious exercise? Like, if that's you're a Christian and that's your calling, you're a baker, should you be free in how who you make cakes for, and participating in a marriage ceremony that you consider holy, and all those sorts of questions. The Supreme Court really ended up sidestepping that one, so we're probably going to see it again. And instead, what they did is they kicked it back down to Colorado because the Colorado Civil Rights Commission was inconsistent in how they were applying that law, and were actually from the very beginning pretty hostile towards the Masterpiece Cake Shop. And whatever it may be, hopefully, whatever you believe, you would expect laws to be evenly applied, and they weren't in this case. All right, I know that's a lot. If you have questions or comments, let me know. Hopefully, we've clarified the basis of the free exercise clause. Long version short, you can believe whatever you want. You can do a lot of things in your religious practice. The general limitation is, does it violate sort of public morality and public expectations? So we still consider polygamy bad. If you're sacrificing, small animals, if you're doing that quietly out of the way, that's probably okay. Doing it in the middle of the street, probably not okay. Depending on what state you live in, is what sort of drug use you can bring into your religious practice, and is it traditional or not. So hopefully that all works. Good luck.